feel free to do so. Okay.
I'm back with maybe in my car.
Okay.
In my building.
I get a notebook. And welcome. This isn't something that Neal or John and I do every day. It's pretty rare. This is a pre-trial conference, and court reporter, you can start reporting now. Okay. This is a pre-trial conference. Anytime the court reporter needs somebody's name spelled, or I'll try to keep people from talking over one another, but just raise your hand and I'll stop and let them spell their names for you so you can keep up with everybody, okay? And I'll go ahead and to make it easier for you right now to identify everybody. My name is Edward R. Sempkowski. So like that, S-E-M-P-K-O-W-S-K-I. I'm the chairman of the Civil Service Board. To my left is Neal Johnson, N-E-A-L.
N-E-A-L.
J-O-H-N-S-O-N. To my right is John Fassler. He is also a member of the Civil Service Board. His last name is spelled F-A-S-S-L-E-R. Attorney Chris Capps is in the back of his name tag. He represents the Sheriff's Department. That's James Coffey, who's the client of Mr. Link Gibbons, who is seated at the end of the table. And in the blue shirt is Chief Deputy Wayne Mize of the Hamblen County Sheriff's Department. He spells his name M-I-Z-E, not M-I-S-E. Okay. All right, this meeting is called to order. And we have, this is a pre-hearing conference. What we're going to do is limit what we're going to do at the actual hearing. And today we'll pick a hearing date, but right now we're going to actually limit what we're going to do. To give some background on 6/21/21, there's a videotape incident concerning Corey, C-O-R-Y, Corey Richard Kyle, that involves former Lieutenant Coffey. Also on that date, 6/21/21, there's an incident report that was generated as a result of that incident. On 7/19/21, Chief Deputy Wayne Mize terminated Officer Lieutenant Coffey via written termination letter in a timely manner, and the next day, which would be July 20th, 2021, they want to sell me a car warranty. Or now, at my age, they want to sell me final plan arrangements. On 7/20/21, Lieutenant Coffey, in a timely manner, filed a written request for hearing. And it's a long request, and we're going to go through this and narrow it down. On 7/23/21, this Civil Service Board, we issued an order staying the hearing until the conclusion of a criminal case that's under investigation by the district attorney's office concerning Mr. Coffey. Subsequent to that, on August 4th of 2021, via certified mail, attorney Link Gibbons, who represents Mr. Coffey, filed a letter pursuant to the Open Records Act wanting copies of the Civil Service Board's rules, policies, procedures, and regulations. On August 4th of 2021, I mailed a letter to Attorney Gibbons, or strike that. I don't know what day that was, sometime in August. I mailed a response to Attorney Gibbons' letter stating that those regulations can be found in the Register of Deeds office. There are a public record there. On August 4th, 2021, via certified mail, Attorney Gibbons filed another open records request to the Sheriff's Department, keeper of records, asking for copies of video, complete personal file of Mr. Coffey. On 8/10/2021, the board does an order of pre-hearing conference to narrow the issues and decide who's going to testify, and that's set for today at 10 o'clock. We're in that pre-trial conference now. It's an open meeting or conference. Our rules say that it shall be in public, so I think Ms. Noy is here today, and she's welcome to be here. It's an open meeting. I see a county commissioner here. He's welcome to be here. It's an open meeting. Okay. Mr. Capps, tell me what witnesses you're going to call.
Chairman Sempkowski, we believe that we will call Chief Deputy Wayne Mize. We will call Jailer Chris Davis.
Hold on one second. Wayne Mize. Chris Davis.
Yes. Very likely we will call Chief Jailer Teresa Laws. And we will present the videotape of the incident that is complained of, as well as incident reports that arose out of the incident that occurred, I believe 6/21/21. We would simply say also, Chairman Sempkowski, that when initially contacted regarding this situation, as you have stated, we were advised that it would not proceed due to the possible criminal investigation or criminal investigation ongoing. And I did not receive the mailing regarding witness lists and exhibits until Wednesday of last week. I attempted to get with Chief Mize to get witness and things for
Right.
Mr. Gibbons, and we're not able to do so in written form, but we will do that. But I would say we don't plan to present any witness that is not already on Mr. Gibbons' list, and any exhibits that are not on Mr. Gibbons' list.
All right, and I've spoken to my secretary, Kim Seif, about that, and she'll get those things out faster next time.
I think it was the mail, actually.
Yeah. Okay, Mr. Gibbons, are there any objections to the witnesses that Mr. Capps is going to call, or the two items that he identified as he is going to introduce into evidence as exhibits?
No, sir.
Okay, thank you. Mr. Gibbons, I have in front of me the request for a hearing that's signed by James Coffey. It's a long request for a hearing. And let's talk now about, or strike that. Let me tell you what the board's role is. According to our rules and regulations, this civil service board cannot alter, amend, modify, decrease, or increase any discipline that the sheriff's department gives to an employee. That's simply not our job. Our job is to determine whether the termination of Lieutenant Coffey was arbitrary, and arbitrary means unreasonable. It means without reason, without consideration for any law or procedure. And the second thing we decide is that whether the termination of Mr. Coffey was for a political or personal reason. That's basically what we decide. Also, as I read the jail policies and procedure in section 3.6 on the last page, they talk about any actions that, by that I take it they mean any disciplines shall be done in good faith. So with those parameters, I ask you first I'll ask you what witnesses you want to call.
Thank you, Chairman. I submitted last week to Mr. Capps, and I also sent via mail. I don't know if you received it or not. I have it here today.
I have not.
I submitted a proposed witness list as well as a proposed list of exhibits. Sure.
Thank you. Okay, Mr. Gibbons has handed to me a witness list, and what we're going to do, I'm going to go through this. My board members or associate members or fellow members have allowed me to do most of this procedure. When you're through, we will meet and decide what we will meet, not in hearing. We will adjourn the hearing, which means Ms. Noe will have to leave for that, and county commissioner will have to leave, and everybody else will leave. It'll just be the three board members. Court reporter can go outside, and we'll decide what witnesses you're going to be allowed to call and what exhibits you're going to be allowed to enter. Okay, I see the first name on your list is Sheriff Esco Jarnigan.
That's correct.
And what's the purpose of Mr. or Sheriff Jarnigan testifying?
I believe he'd have knowledge regarding policies, procedures, termination, decision, any prior similar incidents.
Slow down, speak slower.
We think you'll have knowledge regarding policies, procedures, the termination decision, and then any prior similar incidents.
Well, is there any proof that Sheriff Jarnigan was the one who initiated the termination?
Chief Mize told me.
Mr. Coffey, keep quiet like you're spoken to. I'm talking to Mr. Gibbons.
Your Honor, he's the sheriff. At the end of the day, I imagine all termination decisions have to run through him at some point in time. It was Chief Mize that actually signed the termination notice, but I would hope that the sheriff certainly has knowledge of the personnel decisions that are made within his department.
Okay. Who's your next witness?
Chief Mize.
Okay, that's on Mr. Capps' list. Next witness,
Chad Mullins.
and what information does he have that is relevant or material to those parameters I just set out?
Sure. Same thing, policies, procedures, termination decision, and any prior similar incidents. There was also a meeting that Chad Mullins conducted with Mr. James Coffey prior to termination that included the investigator for the district attorney's office, Mr. Bob Ellis. Those two were present along with Mr. Coffey during that meeting regarding the incident.
Who else?
Teresa Laws, who Mr. Capps has already proposed as a witness.
Who else?
FTO Josh Marcy.
Well, what is FTO mean?
Facility training officer.
And what is his proposed testimony?
Regarding the training that's provided to officers on the use of force continuum, as well as policies and procedures of the jail.
He's a sheriff's department employee,
Yes, sir.
and he's a training officer
Yes, sir.
that trains officers in the use of force.
Yes, Your Honor.
Who else?
Mr. Chris Davis, who was present at the time of the incident, can be viewed on the video as well.
Who else?
CO Kevin Tate, he was also present prior to the video, what was shown in the video. He was there to witness Mr. Kyle's conduct towards Mr. Coffey.
Is he on the video?
No, not that I'm aware of.
Have you seen the video?
I have.
Okay. And I meant to ask both you attorneys, in my previous order, I said that you gentlemen are to view the video, get copies of the incident reports. Has that been done?
I've provided Mr. Capps with documents. I have not received any documents, but if he's not using any outside the ones I've provided, then it shouldn't be an issue.
I would anticipate not using any other documents other than what are listed here. I mean, we've got possibly some that are not relevant as far as this hearing is concerned, but that's on this list. We don't have any other documents.
Okay. Your next witness listed, Mr. Gibbons, is one George Marshall.
He is a nurse here at the jail. He'd be able to testify as to Mr. Kyle's condition following the incident.
How is, what do you mean, are you talking about injuries?
Yes, yes.
How is that relevant or material?
Well, part of Mr. Kyle's complaint was that he suffered injury as a result of the accident. That was one of the things that Mr. Coffey was questioned about. And my understanding, part of the reason that they decided to look in further to these assault charges, and so we believe it would be relevant to the incident itself.
Richard Corey Kyle,
That's the inmate that was involved.
is he represented by counsel?
I don't know, Your Honor.
Well, I would, and I'm not telling you to do this, but I would suggest that either you, probably you, since you're gonna call him as a witness, or want to call him as a witness, if we allow that, we haven't decided yet, but if we allow that, if he's represented by an attorney, you're gonna need that attorney's permission for him to testify.
Well, I understand that, Your Honor. I can certainly attempt to contact him, but I assume that would be the board's responsibility to subpoena witnesses, and if he is represented, that he would notify counsel to be present with him.
Well, no, you're not putting work on us. If you're gonna call Richard Kolkoff, and we haven't even decided whether we're gonna allow him to testify, you're gonna have to decide if he has an attorney. You're gonna have to.
How am I to know that, Your Honor?
Huh?
How am I to know that or find that out? It's my understanding he's still incarcerated here.
Well, you talk to him. You talk to him.
How can I contact him, though, if he's represented by counsel? I mean, that's the
Let
issue.
me interject something here real quickly, gentlemen, that maybe nobody has noticed. That there was a videotape that has been proposed as an exhibit in which he speaks about an attorney, and whether that attorney does represent him or not, I guess would be the question. Talked about talking to Ms. Terry. So, there's that.
I'll certainly be glad to contact Ms. Terry and see if she is representing him.
Okay, I'm just telling you. I don't wanna get you in trouble with the disciplinary board.
Well, I know, that's why I would certainly prefer if the Civil Service Board was the one that would issue the
No,
subpoena.
we're not gonna do this work. We're not doing this work.
Is that not part of the duties to issue subpoenas in this hearing and to call witnesses?
It is. We may issue subpoenas. The
Right.
rules say we may issue subpoenas. That's the determination Mr. Fassler, Mr. Johnson, and myself are going to make, whether subpoenas are issued. We may issue subpoenas. The language does not say we shall issue subpoenas, that we may issue subpoenas.
I understand that.
Okay.
And it's my request that this board issue a subpoena if it allows him to testify. If you choose not to allow him to testify, then we certainly will note that objection.
Okay, and then you have any all witnesses listed by the county, and any all witnesses, rebuttal witnesses, of course, you don't have to list, or you don't have to list those. Okay, so that's your witness list, proposed witness list. And the way these subpoenas are gonna work, gentlemen, is the board is not going to draft your subpoenas for you. You draft the people we decide that we're gonna allow to testify, you gentlemen draft the subpoenas, and you can drop them off at Kim Sipes' office. She's the board secretary, and she's in contact with me every day, practically. And she will email me or call me and tell me the subpoenas are there, and either myself or Neal or John Fassler will sign those subpoenas and issue them.
Do I need to issue subpoenas for the sheriff's department employees? Excuse me.
Of course, unless you can talk to them, and they say, Mr. Gibbons, you don't need to give me a subpoena, I'll be there.
That's all my question.
You know, if they'll do that, fine.
Sure.
If you wanna compel them to be there, you issue a subpoena.
Okay, I'll be glad to do that.
All right, what's your proposed exhibit list?
The June 21st video of the incident, excuse me. The employee termination form that's dated July 19th.
Hold on. June 21st video. That's a video of the incident, am I correct?
That's correct. And it's on page 2 of the document that I just provided to you. Those should be listed. Proposed exhibits.
It is.
Okay.
All right, June 21st video, what's your next proposed exhibit?
Employee termination form dated July 19th, 2021.
That's the one signed by Wayne Mize, am I correct?
That's correct.
Okay, next proposed exhibit.
Jail incident report dated 6/21/21.
Next one.
4 and 5 are both incident reports related to previous incidents that occurred within the jail in which.
Take them separately.
Okay. 7-2 is regarding an incident that previously occurred in which a corrections officer struck an inmate that was restrained. There was no punishment as a result of that incident. We believe that incident was well in excess of any force that was used in Mr. Coffey's incident, and those were not handled similarly. Therefore, we believe that would be proof of an arbitrary decision made in this
Now,
case.
you didn't listen to me, what the word arbitrary means.
I understand what it means, sir.
Well, you, apparently you don't. You didn't listen to me. Arbitrary means without reason. It doesn't mean inconsistent. We're not here, this board is not going to go through every employee that has ever been disciplined and see if it is inconsistent with discipline that was handed down to Lieutenant Coffey. That's not our role. To review maybe perhaps tens, maybe hundreds of incidents of discipline and compare them to see whether they're consistent. Our job is to see if the termination was arbitrary, without reason, without according to any rule or procedure. That's our job.
Well, and if incidents are not treated similarly, then it would lead one to believe, in comparing apples to apples, that if you don't handle things in a consistent manner, that it was for a personal reason or potentially a political reason, which is also a basis in which a decision can be overturned.
There's nothing in our rules of procedure that say what you just said. Our rules of procedure talk about what I've already said for now the third time. We are to judge whether the termination was arbitrary. We are to judge whether the termination was for political or personal reasons, or we are to judge according to the procedures of the jail whether the termination was in bad faith. We're not here to weigh other disciplines and see if they're consistent with what happened to Mr. Coffey. We'd be here for a year if we're gonna do that.
How are you to show, I mean, you have to be able to use similar incidents and the discipline that was provided in order to show personal reasons or that it was an arbitrary decision.
Again, arbitrary means without reason. It doesn't mean inconsistent. I got a law book in my car. You want me to get it and show it to you?
No, I'm very familiar with the arbitrary standard. I handle administrative hearings quite regularly. So I am familiar with that.
Well, so am I.
I understand, and I'm just saying that's the basis of this document, the use that I'm proposing it for.
And that was number what?
That was number 4.
Okay. And that was dated 7/2/19, is that 2
That's
years
correct.
ago?
That's correct.
Okay, what's next?
It's another jail incident report dated 10/1/19 that involved the same officer as the 7/2 incident. Again, inmate was struck. There was no discipline that was issued as a result of that incident.
Okay. And I don't mean to get loud or, I'm just a layperson, okay? I'm not trying to be obnoxious here. I'm just trying to get us through this procedure. What next?
Written statement of Chris Davis dated July 15, 2021 regarding the June 21st incident.
Well, you told me that you're going to or that you want us to issue a subpoena for Chris Davis, why in the world will we need his written statement if you want us to issue a subpoena for Chris Davis to appear and testify?
It's part of the investigation file. My understanding, there was a written statement. I mean, he can certainly testify to.
Well, you told us you want him to testify.
Sure, absolutely. I want him to testify regarding the written statement and the incident itself.
Okay, I think we're on number 7, right?
That's correct.
Okay. Hamblen County Jail Policies and Procedures, beginning at section 2.8.
That's the rules of conduct, that section, particular section is.
Sure.
Okay.
Well, no, I strike that. I retract the word sure. We have to talk about this. What's the next thing you want?
Hamblen County Jail Policies and Procedures 3.6, that's regarding officer and employee discipline.
Okay, what's the next thing you want?
Section 3.8, officer and employee conduct.
No, wait a minute. What number are you on?
Number 9.
Number 9?
Yes, sir. Hamblen County Jail Policies and Procedures 3.8.
Okay, what's next?
Hamblen County Jail Policies and Procedures 8.1, that's regarding response to resistance from inmates.
Regarding what?
Response to resistance from the inmates.
And I'm sorry I asked you to repeat. I'm an old man and I have hearing
That's no problem.
difficulties. So I sometimes have to push my hearing aids in to hear. I don't mean to be disrespectful at all. I just do have a handicap.
That's no problem.
What's next?
I had requested a copy of the investigation file, but I have not been provided that. It was my understanding from the response to the open records request that apparently that file is at the DA's office and it was not made available to me. I would renew my request to be able to review that prior to this hearing taking place.
I don't think this board, if there's an active investigation going on, this board does not have the authority to order District Attorney Dan Armstrong to turn over to us his investigatory reports.
That's not what I'm requesting. I'm requesting the sheriff's investigation file of this incident, who they spoke with before making the employment decision, not the criminal investigation file.
Do they have one, Mr. Capps?
I'd have to defer to Chief Mize on that. Again, as late as last Wednesday, when I was trying to get together with him to get our exhibits and witnesses together, which we were not able to do. I will have to inquire of him. I would feel like there probably is an investigation file, is there not?
Yes.
He would be entitled to that probably.
All right, next number is 12.
That is a July 15th video of Richard Corey Kyle's visitation with his sister, which he describes how the incident occurred. If we do not call Mr. Kyle as a witness, I would ask that video be allowed. Chris, did you say that you intended to use that as well or not?
I don't have any intention of using it, but that's your, if you were going to use it, certainly. We don't have any other exhibits or witnesses other than what's on the list is what I meant to say.
How do you get that into evidence?
As to him describing the incident?
You're saying it's a video recording of inmate Corey Richard Kyle talking to his sister
That's correct.
during a visitation period.
That's
Am I correct?
That's correct.
How do you get that into evidence?
Well, I don't know that we will introduce it into evidence. I would like to have it available either for impeachment or rebuttal purposes if we.
Well, how do you get it? No, my question is, how do you authenticate it? How do you get it into evidence?
How do I authenticate it? It was provided as part of the open records request by the records custodian, which would be a business
The open
record.
records request has nothing to do with court rules of procedure, which we do or do not have to follow. How do you authenticate that tape?
It's a public record that was produced as a business document of the sheriff's department.
Is that correct, Mr. Capps?
I think the sheriff's department did produce it, and, subject through the Open Records Act, it was not an exception to the Open Records Act. Whether it required permissions, or releases of the individuals involved, I quite frankly am not aware of whether it did, but it was provided, and it could certainly be held to be a business record.
And I think, Mr. Gibbons, that pretty much covers it, right?
That's correct.
Okay. Now, Mr. Capps, what do you say about his list? He's provided you this list, right?
Chairman Sempkowski, he has provided the list. The incident reports dated back in July of 19 and
No,
October.
let's go over the witnesses first.
Okay.
He wants us to subpoena Esco John.
I think what Mr. Jarnigan would say would be
No,
probably.
I don't want to know what he's going to say.
Cumulative.
You object to testifying.
I don't think that his testimony is going to add anything to this hearing, so I would say yes, we would object to that.
Wayne Mize.
Wayne Mize will.
Of course, he's on your witness
He
list.
is as well.
Chad Mullins.
If Mr. Mullins had knowledge of the manner in which this decision was reached to terminate, I think he would be probably a valid witness to call.
Teresa Laws.
Again, Teresa Laws is probably a cumulative witness. I don't know what she can add to it other than she's the chief jailer, and this incident occurred in her jail under her authority. If she had a part in the decision making, then I think she would.
Well, you've already listed her as a witness, so you're arguing against yourself.
I'd say she's okay.
Okay. I would think so, since you've listed her as a witness.
Well, we hadn't submitted a list.
Well, you told me.
Well, I did. You're right. I'll be held to it.
John Marshy. He's the training officer that apparently trains officers in use of force training.
It could be relevant to the decision making.
So you're objecting to that?
We're not objecting to Josh Marston.
You are not?
Not objecting to Josh Marston.
Chris Davis?
He's our witness.
Kevin Tate?
We don't have any, we object to Mr. Tate. We don't think he's a relevant witness to it.
George Marshall? That was the nurse, apparently.
Don't think I don't think that Mr. Kyle's condition after this incident is relevant to the decision that was made. And I think that's, I don't know how it could relate to.
So I'll take that as an objection, right?
We would object.
And Richard Corey Kyle Jr.?
Chairman, I have not had an adequate opportunity to talk with Chief Mize about the witness list and whether or not that's, if we could have a brief moment to talk about that, I think we would be better served in a couple of.
Okay, well, you can, you mean now, or when we take a break
Well,
and we decide which witnesses?
If I could just let the chair know, and before we leave this building, whether we
Okay.
object to that. Mr. Gibbons, is that okay?
Okay, that's fine.
Okay. Now, all right, that's all the witnesses. The exhibit list, the June 21st video, you've already told us that you want to introduce that, so I suspect you have no objection to that video.
No objection.
And you've already said you're gonna introduce the, well, no, you didn't. you want to introduce the employee termination letter. I noticed in interviewing you that you haven't listed that as an exhibit, which seems to me to be pretty darn relevant.
I think it's very relevant. We have no objection to it.
Okay. And the incident report concerning the 6/21/21 incident?
Clearly no objection.
Other incident reports. And I'm looking at number 4 of Mr. Gibbons' list.
Items 4 and 5, we would object to as not having a reasonable, relevant relationship to this incident and what this board is called upon to do. So we would object to those two items 4 and 5.
And I mean, once to call Chris Davis, who's on video and actually witnessed this, and then he wants to introduce a written statement of Chris Davis. Seems if you're gonna have that witness testify, why in the world would you need his statement? But yeah.
I would anticipate that if he testifies, he would submit that statement through his testimony. And I can't say that would not be some proper relation to the situation.
So you're okay with it?
We're okay with it. All the jail policies and procedures are fine. It's our own handbook. That's 7 through 10. We're down to number 11.
The investigation file, again, you're gonna have as difficult a time as this board would have in going to General Dan Armstrong, who's the Chief Investigative Officer for the 3rd Judicial District. He has a case that is under investigation. We're all gonna have a difficult time getting Dan Armstrong to turn over some investigation report to somebody else.
I think the investigation file that he is seeking is the sheriff's investigation file of the incident itself, not the criminal investigation. However, because there is a current criminal investigation, I think we would have to touch base with Dan, with the DA's office, and see if that's something that we can produce. It may well be.
Well, and that's correct. I'm just looking at the human resources file, for lack of a better word, that would be used whenever, I assume they spoke to Mr. Kyle, they spoke to other witnesses, Chris Davis, anybody else that was in the vicinity. That's typically how human resources investigations are done, and I'm certainly not asking for Mr. Armstrong's criminal investigation.
Or you want the sheriff's investigation file?
That's correct.
Okay, what do you say about that, Mr. Chairman?
Again, let me, first of all, what I've said is that the DA's office may have some input on that. They may or may not want us to produce that, but if they say they have no problem with it, I still need to confer with Chief Mize as to how we should respond to this. My feeling is that we don't object to it if the DA's office does not have a problem with it. But that's just a feeling. I don't want to be a waiver or anything like that. I really need to.
Well, you say, okay, if Dan Armstrong will give you permission.
And if I get a chance to consult with the chief again, because, again, this short period of time that we've had to look at this together has only been since, actually, we've only actually looked at it once since I got your mail on Wednesday. Chief was out on Friday. I talked with him Thursday and again this morning, but we haven't had a sufficient time to talk about it.
I'm down to number 12, gentlemen. June 15, 2021 video, Richard Corey Kyle visitation with his sister.
We would object to that. We don't feel it has any proper relevance or bearing on what the board is called upon to decide.
Okay, now, thank you, gentlemen. Now, there are other people who witness this. Nobody's gonna call them?
We're only aware of Kevin Tate, Ethan Ferguson, who is no longer employed with the Sheriff's Department. We do not intend to call him, and Chris Davis
Okay.
being
You got
witnesses.
Chris Davis listed, I think, right?
Yes, sir, as well as Kevin Tate.
Okay. There's an Ethan Ferguson that witnessed this also.
He mentioned that, but he says he's no longer employed by the sheriff's department. Would he be someone, Chief Mize, that we would be interested in calling?
I would not think so.
Let's see. I'm looking at, to keep everybody on the same page, what I'm looking at is Mr. Coffey's request for a hearing dated July 20th, 2001. He requested a civil service hearing for his wrongful termination. He's gonna have one, this pre-hearing conference. Before we leave today, we'll set a date for a hearing, okay? He says that he had a right to know about an investigation. I have worked, I practiced law for 47 years, worked with the district attorney's office for about 20. I never knew an instance when I or anybody in my office would inform anybody that they're being investigated. So, yeah, that's irrelevant, that he was not found informed of any such investigation. About injuring Mr. Kyle, I'll probably, or we'll talk about it and probably let you call the nurse, but the fact whether Mr. Kyle was injured or not isn't really material. And an assault, and we're not a criminal court, okay? Our burden of proof isn't like they have in criminal court, where proof beyond a reasonable doubt so that the mind rests easy on the issue of guilt or innocence. We don't have that burden of proof. And furthermore, in the criminal statutes, which we're not concerned with here at this administrative hearing, there doesn't have to be any injury to have an assault. So, all right, Mr. Kyle's proud criminal history. Mr. Gibbons hasn't asked for that, so that move past that. Mr. Coffey wants to tell his side of the story, which nobody has ever asked, and he'll certainly have a right to testify. He certainly has a right to testify, to tell his side of the story. I just want to let Mr. Coffey and his attorney know that the district attorney's office is going to have access to this court report.
We're aware of that.
Okay. So they can use that against you.
Honestly, we've discussed
If the
that.
grand jury returns an indictment and you go to trial, they can use what she's taping. I wish to discuss other things that are totally wrong with the department. No, we're not going down that road. I can prove that I have been a target for them since they took office. Again, that goes back to what I said before. Part of our duty, Neal Johnson and John Fassler, myself, is whether this termination was done for any political or personal reasons. So, if he can prove that it was done for political or personal reasons, okay. All right, if there's nothing else right now, if Mr. Fassler and Mr. Johnson can have a moment, we'll adjourn this meeting right now, and we're gonna meet by ourselves, which is not part of the hearing, Ms. Noe. It is not part of the pretrial conference, so it is not public. So you'll have to leave also.
Well, let me ask, why is it not public? Are you not deliberating on who you're going to allow?
That's right.
What is the exception for you all to deliberate in private?
Well, we do it all the time, and that's our rule. The Civil Service Board can make up their own rules, procedures, and regulations.
And I have not had that much contact with the Civil Service Board for 20 years when Lynn Wolf was involved. But you are deliberating to make a decision.
You are not going to be allowed to be in here during our deliberations.
What is the exception to the Open Records or the Open Meetings
I don't have
Act?
to respond to your questions, and I'm just telling you, you're not going to be able to be in here recording us when we are deliberating which witnesses we're going to call and which exhibits we're going to allow. We're not going to do that. You're not going to be able to be in here.
I hear you saying that. I'm just asking for your legal basis for excluding the public from your deliberations.
Because it's not part of the pretrial hearing. I'm going to adjourn the pretrial hearing. I'm going to say the words, "I adjourn this pretrial hearing." And at that time, what we discuss is between board members. It's not public. When I reconvene, you'll be able to come back in here with your camera and continue to record.
Is your attorney staying in here?
I'm sorry?
Is your attorney staying in here?
No. My attorney?
Well, the Civil Service Board attorney, is that not Mr. Capps?
Number one, I'm not getting any discussions with you about legal procedures. Chris Capps is not the attorney for the Civil Service Board. Chris Capps is the attorney for the Sheriff's Department. Now, at the city of Morristown, the Civil Service Board, if they have hearings, they hire attorneys to represent them. We've decided not to do that. So, Chris Capps is not our attorney.
Okay.
Link Gibbons is not our attorney.
And you are not meeting with an attorney in an executive session then, right?
It's going to be the three of us, John Fassler, Neal Johnson, and myself. Okay, is there anything else, gentlemen? And our secretary is going to stay in here too.
Is she taking minutes of your discussion?
No, she's my secretary.
Why is she staying?
She may tell her Xerox things or things of that nature, administrative things. She is not going to participate in us deciding which witnesses are going to be called and which exhibits are going to be entered. She will have no decision in that. If there's some administrative duty, like we make a copy of this, we'll give it to her and she'll make a copy. Other than that, no, she's not going to be part. She's not part of the Civil Service Board.
Correct.
All right.
I would like to go on the record with an objection to your meeting. I think it may violate the Open Meetings Act.
Well, you're not a party to this action.
I
So
could
I don't
sue,
see how
but
you can make an objection. Perhaps you need to go back and reread your basic rules of evidence, Ms. Noe, and see if somebody who's not a party to an action can make an objection to a hearing in which they have no interest.
I just want it on the record. I'm talking about the Open Meetings Act, not about rules of evidence. The Open Meetings Act.
Okay.